All right, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, and welcome to the Massachusetts Appeals Court oral argument session. I'm Greg Massing, and our panel today consists of Justice Shin, Justice Ditkoff, and myself. As you know, the argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. We will follow the same rules as in a physical courtroom. Each side has 15 minutes to argue, and we'll ask questions. Only one advocate may speak at a time. The session clerk will actually mute the other advocates until it's your turn to speak. There's no rebuttal. You do not have to stand. Feel free to sit if you prefer. Clerk Sullivan will display a countdown clock once we get going, and this proceeding is being recorded. So anything said during the proceeding will be heard by all those observing and become part of the record, just as in a physical courtroom. If we have any technical problems with the connection or with any of your connections, we'll stop the argument and announce there's a problem. We may suspend the argument momentarily, and the clerk may remove participants into the waiting room until the problem is resolved. Hopefully that won't happen. As always, we have read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, we won't hold it against you if you don't. And with that, I'm going to call the first case for this morning, which is Commonwealth versus John Yang, 2019 P326. And attorney, is it Cowan?
Piltzer Cowan. Thank you, Justice Massing.
Piltzer Cowan. You have the floor.
Thank you, Your Honor, and may it please the court, Andrew Piltzer Cowan for the defendant, John Yang. The issue before the court today is whether the Superior Court committed reversible error in three respects, admitting evidence identifying John Yang as the perpetrator who was known otherwise as Chi. Those three, to remind the court, number one, which I will spend most of my time on, unless the court desires otherwise, was a Polaroid photograph depicting an Asian man with a scantily clad woman and bearing the inscription, "Chi, keep it nasty," that was admitted without any foundation as to who wrote the inscription, to whom, for what purpose, when, etc. The second was an unequivocal in-court identification by a cooperating co-defendant who had previously been only 80% confident in his out-of-court identification of the defendant. And the third was a lay opinion by Detective Daigle identifying the man in that Polaroid photograph as the defendant. Turning to, I'd like to sort of disambiguate and respond to what I think are a couple of the key friction points on the argument about the Polaroid photograph. So the inscription, "Chi, keep it nasty," by itself literally asserts nothing of relevance to the case. The reason that that inscription was relevant, the reason the Commonwealth introduced that piece of evidence, was as evidence that Chi was the defendant, John Yang. And the problem with this is that we have no idea who wrote that.
That's not quite true. The way they tried to prove that it was, in fact, a picture of the defendant was through the testimony of Detective Daigle. I know that's your third issue, but that was their argument on how they were establishing that that was a picture of the defendant.
Thank you, Justice Ditkoff. So there were two connections that the Commonwealth needed to make in order for this photograph to be relevant, right? One is that the picture is Chi, and the second is that the picture is the defendant. Therefore, the defendant is Chi. That was the Commonwealth's argument. And so Detective Daigle's opinion, as well as the jury's ability to compare the photograph to the defendant on their own, as well as the identification by the co-defendant. The identification of the co-defendant got them directly to John Yang as Chi. Detective Daigle got them the man in the photo is John Yang, and the inscription got them the man in the photo is Chi, right? So without the inscription identifying the man in the photo as Chi, a photograph of John Yang found in his brother's apartment would have had very little evidentiary relevance to the case. The Commonwealth argues in their brief that it was relevant as associative evidence to prove that the defendant had some connection to that apartment. The problem with this argument is that the defendant having a connection to the apartment wasn't the centrally contested issue. And in the cases where we see issues of associative evidence that the Commonwealth cited in their brief, it's virtually always an issue of, okay, we found some cocaine in the sock drawer. Whose cocaine was it? Whose sock drawer was it? As among the people who lived there. Well, all of the defendant's personal papers with their name on them were found in another drawer of the same dresser, for example, or on top of the dresser.
If the key evidence here is that the picture is of Chi, suppose the defendant, instead of being found in the apartment, suppose that same picture was found in his wallet. Would that be a completely different case?
I think it would
He's carrying
still
around a picture that says, I'm Chi.
So I think that would be a slightly different case, Justice Massing. I think it would still be a problem for the Commonwealth, but I think there's also a difference. Does the picture in his wallet say, I'm Chi, or does it say, Chi, keep it nasty? Because one of the inferences that the Commonwealth needed to get for this to be relevant was that that inscription was addressed to the man in the photograph. And the problem is we don't know that. We don't know if it was addressed to a third party. We don't know if, we don't know how the writer of the inscription associated the name Chi with the person that the writer was addressing by that name. So
Right,
the Commonwealth.
That's why I'm saying if he's carrying it in his wallet, then that's in a way that's him. That's like Coney at trial. They argued this was like Coney, where the defendant has a license that says his name on it, and the court says it's not being used for the truth that that's his name. It's being used for the purpose that he's carrying it around. So he's holding himself out. So is there no analogy there that the apartment that he uses has a picture that he keeps there that says, "Chi, keep it nasty"?
The distinction, I think, Justice Massing, and this is also the important distinction of Coney, is that in Coney, the identification card bearing that name was not just found on his person. He actually took it out and handed it to the officer, right? When asked for his identification, he proffered a card bearing the name Roger Coney and bearing the address to which the suspension notice was sent. And the issue at trial, this was driving on a suspended license case, and the defendant was trying to establish a reasonable doubt as to whether he'd received notice of the suspension. The issue is whether that identification card was admissible evidence that he received notices mailed to the address on the card. And it's essentially an admission of a party opponent when he hands over that card to say, I am this person. And I think that's the important distinction between Coney and both this case and your hypothetical, Justice Massing, is when we talk about holding oneself out, the actual act of proffering that piece of evidence as identification of oneself, I think is crucially important to distinguishing Coney from the facts of this case.
Counsel,
Go ahead, Joe.
Counsel, have you seen this photo?
I have, Justice Detkoff.
How much does it look like the defendant?
So that is, I'll put it this way. It's a Polaroid photograph, as I think we were all amply familiar with in the 80s and 90s. It's much lower resolution than, say, an HD photograph taken with a modern digital camera. It's taken under low light. There's not a whole lot of detail on the features, so it clearly depicts, an Asian gentleman of about the same age and certainly similar physical appearance to the defendant.
Does it show the tattoos?
I honestly don't recall, Justice Massing, if it shows the tattoos. The photograph was in evidence below. We debated including it in our record appendix or not, and ultimately chose not to, but I think the court could ask for it if the court wanted to see it. I think to address what I think both of your honors are getting at with the third issue, I think there was sufficient evidence that if the jury looked at the photograph and if the jury looked at the defendant and concluded unanimously beyond a reasonable doubt that the photograph depicted the defendant, that is an inference that this jury would have been allowed to draw on this record. So our objection to Detective Daigle making that conclusion for them is that it's an impermissible lay opinion under Commonwealth versus Suarez. The jury is capable of making this comparison themselves. And the Commonwealth argues in their brief that this was either not error or not prejudicial. But I think they say it's not error because the defendant changed his appearance. The testimony about the changes in his appearance were that he had a hairstyle in, I think, 2014 at the time of the offense. He had a ponytail and later did not, and that he'd lost some weight. So it's not a radical change in appearance, but there was also no foundational testimony that Detective Daigle had the requisite familiarity to offer that opinion. He sort of simply says, yes, that's John Yang.
And what do we know about Daigle's role in this case? He executed the search warrant. Anything else? Did he do the arrest?
I don't think the facts of the arrest were actually in the record, Justice Massing.
Okay. So all we know is that he executed the search warrant.
That's right.
Counsel, do you agree that the inscription on the photograph was not testimonial?
I do, Justice Shin, and I want to be clear, the confrontation clause issue that we raised in our brief is under Commonwealth versus Owens, which is a pre-Crawford case from the US Supreme Court, but as far as we were able to ascertain, still good law. And Owens simply stands for the proposition that there is a confrontation clause right to cross-examine identifying witnesses. You know, we put that citation in because we think it's a good citation and for federal preservation issues. I do think that we have our strongest argument is under the state evidentiary law. And that's why we focused most of our brief and most of my oral presentation on the state common law of hearsay.
The testimony of the witness, D. Wispelair, was that he bought drugs from the defendant for every day for months. Why is this even a Collins-Creighton issue?
Thank you, Justice Massing. Fundamentally, because even though he said that he bought drugs from this man at high frequency over a long period of time, when he was shown a photo array, he was only 80% confident in his identification of the defendant as the man he bought drugs from. There's a cross-racial identification issue, but under Creighton, under Collins, in order for the Commonwealth to put in an in-court identification from a witness who previously was equivocal in an out-of-court identification, the Commonwealth needed to make an affirmative showing that there was a good reason to do so, and the judge needed to make that finding. That simply did not happen. The judge
well, there was no objection, right? I mean, you can argue about whether it was a stipulation or not, but there was no objection to letting that witness testify, identify the defendant.
Well, there was a motion in limine to keep it out, which was not discussed at any particular length, but which the judge denied the motion in limine to keep it out.
This was a pre-Grady trial, so a motion in limine doesn't preserve. Isn't that correct?
This was a pre-Grady trial. I haven't briefed this issue, and frankly, Justice Ditkoff haven't thought about it at the length that I should have. I believe Grady, by its terms, only applied to cases tried after that case was decided. This case was pending on direct appeal at the time that Grady was decided, so under traditional retroactivity analysis, it would apply. I think I should offer to address that issue in a post-argument letter.
But the basis of the motion was that the pretrial identification procedure was suggestive. It wasn't that it was not unequivocal.
That's true. So the Collins, the precise issue that we briefed was not raised in the motion in limine, and I think actually that's the answer to Justice Ditkoff's question, that under Grady, the motion in limine raises only or preserves only the issue that it raises.
So it seems to me that putting aside the photograph and the identification, the in-court identification, that the evidence here was still certainly sufficient to prove that the defendant was Chi. Could you explain why the admission of the photograph, assuming it was error, was prejudicial, and the in-court identification caused a substantial risk of a miscarriage of justice?
Yes, Justice Shin, thank you. And I think what this case really comes down to is, yes, the evidence was sufficient, but the identification was the only contested issue at trial, whether the defendant was Chi. And the issues that we've raised in our brief go to the core identification issues or the core identification evidence that the Commonwealth presented. So if you look at just, what was the Commonwealth's evidence that the defendant was Chi? Primarily, it was the Polaroid and it was the cooperating co-defendant's testimony. The cooperating co-defendant was cross-examined vigorously on the benefits that he had received from his cooperation. He was equivocal as to his pretrial identification, and he had a clear motive to identify the defendant for his own personal benefit. So had the jury not been tainted or swayed, I'm not sure what the right verb is, by the Polaroid, this would have been a case where the identification rested entirely on the testimony of a cooperating co-defendant who was subject to substantial impeachment. There was an alibi defense that was presented at trial. And this was a case where the evidence, while it was legally sufficient, was certainly not airtight or indisputable. And so it's, I think, difficult to imagine that if they hadn't had this photograph that was the only sort of objective, tangible thing and connecting the defendant with Chi that didn't have any sort of motive for personal gain, that they might not have come to a different conclusion.
Okay, you've got your, I guess we're running down, you're running to the end of your clock here. Is any other judges have any more questions? All right, thank you very much. And so we're gonna put you on mute and we'll hear from ADA King.
Good morning, may it please the court. Michelle King, Assistant District Attorney for the Commonwealth. I had first planned on addressing this standard of review issue, but it appears that that's no longer in play. So I'll move to addressing the issue of the introduction of the photograph and inscription, Chi, keep it nasty. As was patently clear at the trial, it was the Commonwealth's position that the photograph and inscription were being introduced not for the truth of the matter, but rather to prove Chi's connection to 45 Forest Street, and as well to show that the defendant held himself out as Chi. If you look at the line of cases that essentially started with Cohen, Cohen was a case where a search warrant was executed at the defendant's house. The police had spoken to a woman who claimed her name was Tina Concrete, and they put that name in the warrant and affidavit. And when they went to the premises, it turned out that Tina Concrete was in fact Tina Cohen. There were documents at the residence, including an identification of Tina Cohen, but more importantly, an envelope that was addressed to Mrs. Paul Cohen. And the court in Cohen said that that envelope was admissible because it showed Tina Cohen's connection to the home, but also that Tina Cohen held herself out to be the wife of Paul Cohen. And so I would suggest to you here the inscription, Chi, keep it nasty, was of the same ilk. Now in Cohen, there was no foundation offered as to who wrote the envelope addressed to Mrs. Cohen, similar to the photograph here. So the foundational premises were exactly the same. No known knowledge of who wrote the inscription, Chi, keep it nasty, and also no known knowledge as to who wrote the envelope to Mrs. Cohen.
Counsel, sorry to interrupt. The issue here is not the admission of the inscription, nor is it the admission of the photograph. It's the admission of the two together. So could you address that? Isn't there an implied assertion there when they're admitted together that whoever the author of the inscription was there's an implied assertion that the man in the photograph is Chi.
Well, I don't disagree that there is some, implied assertion that Chi would be the fellow in the photograph. But again, I would suggest to you that that is merely evidence that the John Yang held himself out as Chi, not that, not definitive evidence.
No, if offered for that purpose, you have a similar problem, which is that there's an implied assertion now that whoever wrote the inscription, there's an implied assertion that the man in the photograph told me he goes by the name Chi, right?
Well,
So it's different. Go ahead.
I'm sorry.
No, go ahead.
It's hard with the streaming. In that case, it's similar to Coney, where the photograph that was handed over to the police was evidence that the person who handed over was holding himself out to be Roger Coney. And so I would suggest to you that that is similar to the case here. You have a photograph with someone's name on it, holding themselves out to be that person.
Right, and so there is a hearsay assertion embedded in the photograph and the inscription together that the author of the statement is saying that this man in the photograph held himself out to me to be Chi, which is different from Coney, where it was the defendant himself who handed over the identification.
Well, I don't see the distinction, Your Honor. The court in Coney was talking about the photograph, and I understand that it's in one circumstance it's Coney himself holding it out, and in another circumstance it's just the photograph itself. But the piece of documentary evidence in Coney was the photograph and his name on it, and the court said in Coney that that was not hearsay, that it was just evidence of the defendant holding himself out. So I suggest that those two circumstances are similar.
Can I ask you about the statement in the closing argument where the prosecutor used the photograph? It appears for the truth of the matter asserted, which is that the man in the photograph is Chi. And I'll read it. It says, the identification of Chi as John Yang, the photographs that confirm that. Isn't that referring to this photograph with the inscription?
I believe, Your Honor, that was based upon the testimony. When he put all the testimony together, he was corralling what was said. And so it wasn't just the photograph, but you had then the testimony of Detective Daigle, which was unobjected to, that the man in the photo was John Yang.
Okay, but the
So
argument
putting the
is
evidence together.
the argument is the photographs confirm that the identification of Chi as John Yang. Are there any other photographs that the prosecutor could have been referring to other than this one?
Well, there was a photograph that was introduced, I believe, by way of the defendant's brother. I believe his name was Moses. That was a picture of the defendant from 2013. But I'm not entirely certain which, I didn't focus on this issue, so I'm not entirely certain which photograph the prosecutor was referencing, but I believe there was another photograph introduced of the defendant from the time period of his arrest. But again, I'm not certain which photograph the prosecutor was referencing. I didn't address that issue because I don't believe it was raised by the defendant.
So I thought there were 14 photographs of the defendant in evidence by the end of the trial.
I believe there were a number of photographs, Your Honor. So again, I'm not entirely certain which one the prosecutor was referencing.
Have you seen the Polaroid? How much of the defendant is visible?
I have seen it, Your Honor. I don't believe his tattoos are visible, but I do believe that there's a very reasonable inference that the photo is that of John Yang.
Now, and I know there was no objection to the officer testifying, and you seem to argue that he, under pleas in that line of cases, he could identify the defendant. But you don't argue that very strenuously in your brief. That's not a great argument. Right? There's the Officer Daigle, he didn't know the defendant or have any connection with him that he could say this is what he looked like at the time, right?
It's not my strongest argument, Your Honor, but I put it out there. There was some testimony by the defendant's brother that his appearance was, slightly different. His hair was longer back when he was arrested, and he was chubbier back then. But there was certainly no testimony as to how Officer Daigle knew the defendant. I believe his only connection to the case was he served the search warrant. So it wasn't my best argument, but I put it out there. My best argument on that front was that because there was no objection, there was no substantial risk involved. And if you look at the identification evidence outside of Officer Daigle saying that the photograph depicted John Yang, you have Kyle DeWestplenaire, who had for months daily interactions with Chi. He testified that he and Mr. Brown went down almost on a daily basis to buy drugs from Chi. He testified that Chi had a dragon tattoo that went from his wrist up to his biceps or shoulder area. And you have photographs of the defendant's tattoos, which depicted the same precise tattoo that was identified as Mr. DeWestplenaire. You have the in-court identification of Mr. DeWestplenaire. You have his photo array identification.
The in-court identification was erroneous, was it not?
It was not, Your Honor.
Why not?
Well, because Mr. DeWestplenaire's photo array identification of the defendant, he picked him out of a photo array, and he said that he was 80% positive that was 80% sure that was the defendant. And the only reason why he had some doubt was because the defendant's hair was different. Now, if you look at Collins talks about an unequivocal identification versus equivocal. Now, Collins involved a witness who said it could be number 4 or it could be number 8. And that was the identification at the photo array. And then at trial, the witness said, it looks more like number 4 on cross-examination, and then on redirects identified the defendant in court as the perpetrator. And so I would suggest to you that this case is highly different from Collins. I would take an 80% certainty quite often, Your Honor. I think that's a pretty high number in terms of identification. I don't believe Collins stands for the proposition that a witness has to be 100% certain to not be unequivocal. It's very different than Collins when the witness said, it could be this person, it could be that person, I'm not sure. Very different. And so
the SJC has, I was interested in this. I shepherdized Collins, and sure enough, the SJC in DEW explains that unequivocal means such that the statement of identification is clear and free from doubt. Would you say this is clear and free from doubt?
Well, Your Honor, I haven't read you, and sorry for that, but I would say, it clear and free from doubt. I don't know if that means 100%, and I don't. I guess I would say that 80% qualifies.
Because my question, though, to Mr. Pilzer-Cowan was, isn't it where the guy, he's seen the guy every day for the past 5 months, doesn't this get into the good cause exception? And the fact, and we've established that the objection wasn't really raised at trial, so that didn't even come up. It might have, though.
Yes, Your Honor. And the other thing I would say with regard to the in-court identification, and defense counsel argues otherwise, but I would urge you to read that part of the transcript with regard to the stipulation, because it's very clear what the Commonwealth and defense counsel agreed to with regards to Mr. DeWestplenaire's in-court identification. And in fact, at the time, when Mr. D. Wesplenair made his in-court identification, there was no objection. And I would suggest to you that that's very strong evidence that defense counsel had in fact stipulated that Mr. D. Wesplenair could make that in-court identification. The issue that they had been fighting over was whether or not Mr. Brown could give an in-court identification, and both sides agreed that he could not because he had not made an out-of-court identification. So I would urge the court to look at the issue of the stipulation closely with regard to a read of the transcript.
You think it's not substantial risk of miscarriage of justice analysis if it's stipulated? Does it change things if it's a stipulation versus just not preserved?
I think it does change things, Your Honor. I believe if it's stipulated to that you don't review it for a substantial risk, it's a non-issue. If there are no further questions, I'll rely on my brief.
I have none. Justice Shin, Justice Ditka? Okay, well, this was our first one of the morning and it went very smoothly. So I want to thank you both for participating. I hope you are well and stay safe. And we'll take the matter under advisement.
Thank you, Your Honor.
And myself. As you know, the argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We will follow the same rules as in the physical courtroom. Each side has 15 minutes to argue. We'll ask questions. Only one advocate will speak at a time, and the session clerk will mute any other advocates until it's your turn to speak. As usual, there's no rebuttal. Clerk Sullivan will display a countdown clock once we get going. So you have time will be shown in her block there. And this proceeding is being recorded, so anything said will be heard by all of those observing on YouTube and become part of the record, just as in the physical courtroom. In this case, there is a victim whose identity is protected by statute. So just as in, we would not refer to the victim by name, and so please avoid doing that because that should not be part of the record. If we have any technical problems, we might have to have a little break in the session. We might put you back in the waiting room to fix it, but hopefully that won't happen. And as always, we've read your briefs and are familiar with the case. You're free to use, you have 15 minutes, you're free to use all 15, but you don't have to. And with that, I'm going to call this case, which is Commonwealth versus Alfred Andrews, 19P 854. Counsel for the defendant, is it Ms. Henrique?
Ms. Henrique. Thank you.
You're on, the floor is yours.
Thank you. May it please the court. Good morning, Your Honors. As Your Honors are aware, after reading the briefs in this case, this is an appeal of the defendant Alfred Andrews to his conviction of assault and battery causing serious bodily injury. The defendant was initially charged with that charge as well as rape and assault and battery with a dangerous weapon. He was acquitted of the rape and assault and battery dangerous weapon, convicted as to the assault and battery serious bodily injury. This is an appeal towards the portion of the conviction of serious bodily injury. And as Your Honors know, initially in my brief, I did brief two issues as to sufficiency of the evidence and also as to the jury instruction and the judge instructing the jurors on the 3 theories of serious bodily injury. Now, for efficiency of the court, I'm certainly not going to attempt to change this court's recent opinion, and specifically Justice Shin's opinion in Commonwealth v. Inoua. I do understand that the court has taken a position on that issue. I certainly would be happy to discuss it further, but I do want to recognize that up front, that I recognize the court's taken this position. I'm not looking to concede the issue, as Inoua is, my understanding is that further appellate review has been filed for and is being sought. So not looking to concede that issue, but I do recognize that the court has taken a very recent position on it. I would, however, argue that by allowing a jury to return a general verdict as to the theory of substantial serious bodily injury, it could create and I would suggest in this case does, a substantial risk of miscarriage of justice when it comes to this court trying to review whether or not there was sufficient evidence to support a serious bodily injury in a case such as this, where several theories may have been suggested to the jury, but we don't know what they actually convicted on. And that does make this review of my argument that there was not sufficient evidence to convict on serious bodily injury, I suggest, very difficult. What we have in this case is a situation where a victim testified to injuries. The same victim, now the jury is granted in their purview what to credit and what not to credit. I understand that. However, in this case, the jury chose not to credit the testimony of this victim to 2 of the 3 very serious charges. We had the testimony of the victim as to the injuries. The testimony of what I would suggest is a victim whose credibility should be questioned. We have the testimony of 2 police officers who saw the victim on the date of the incident and then 9 days later. And what they reported was a serious black eye. We have photographs supporting that. Yes, physically, visually, there is a very serious black eye. However, a black eye itself is not enough to support serious bodily injury, as the case law allows jurors to use their own common sense knowledge in determining serious bodily injury if the injuries are clear and of the kind that one layman would recognize. Then we also know that black eyes heal, even the severest of them. Now, we do have medical records, unexplained medical records that do speak to medical terms such as an orbital fracture, fractures of the teeth, but they don't speak to actual loss of the teeth. We do not have any follow-up medical records as to what the victim claims were these injuries that she had to have follow-up on, such as the plastic surgery for scarring, which she refers to scarring, but we don't know where, when she refers to it during her testimony, we don't know where she's referring it to. And I suggest that the photographs, it's unclear as to what this scarring is and whether or not it was specifically caused by the defendant's actions. So what I'm suggesting is that we're left for speculation that in this case, it's speculation that could cause a serious miscarriage of justice, because we have a situation where we have a victim laying out possible injuries, we have unexplained medical records, we have contradictory evidence of 2 police officers, and we don't know on what theory the jury relied on finding that there was a serious bodily injury. That would be the summary of my argument. I'm certainly would be open to answering any questions. Again, do recognize this court's position laid out in Inoua as to my second issue.
And I mean, in terms of speculation, I mean, you acknowledge that's not the same as whether or not we credit the victim's testimony. I mean, apparently here, you make the point that, you know, the jury found her not to be credible in certain respects, but they did find her credible with respect to the assault and battery and substantial bodily injury. We know that from their verdict. I mean, so you say in your brief, if we were to credit her testimony, then perhaps her impaired breathing through her nose and being on a liquid diet would be impairment of a serious bodily function. Don't we have to accept that under Lattimore?
I think when first laying that out, I certainly was turning more towards the second issue and questioning that. But I think that in this case, where we have the clearly contradictory evidence of the police officers, and the only thing is, Your Honor, Justice Mason said that they credited the assault and battery and the serious bodily injury. Well, really, the assault and battery could be credited to the defendant himself, who testified and admitted that there was an assault and battery. It's possible without that testimony, the jury might have believed nothing as to this victim and what she said. So really, what I would suggest, the only thing they've credited her testimony was the injuries and the effect that they had ongoing 21 days later. Everything else is either is supported by unexplained medical records or the testimony of the police officers, which contradict, again, the testimony of what I would suggest is a very uncredible victim. So in that sense, I think it is left to the purview of the jury to choose what to credit and not to credit. But here I would suggest that what is left is not enough to have been given to the jury in the first place. If there are no further questions, I would rely on my brief.
Seeing none, thank you very much. And we'll put you on mute and we'll hear from ADA Payne.
Thank you. May it please the court, Assistant District Attorney Cynthia Payne on behalf of the Commonwealth. The Commonwealth is asking this court to affirm the defendant's conviction. Here, the trial judge properly denied the defendant's motion for a required finding of not guilty, where the evidence, when viewed in the light most favorable to the Commonwealth, was more than sufficient to prove the elements of assault and battery causing serious bodily injury beyond a reasonable doubt. Here we have both the victim's testimony, which was also corroborated by the medical records, but I would suggest that, again, in the light most favorable to the Commonwealth, the victim's testimony that her left eye socket was fractured. She was unable to see out of her left eye at all for 1 month. And then even at the time of trial, which was a year after this assault, she couldn't really see well out of that eye at night. She testified that her jaw was broken, that she had to have it wired shut, that she could not eat normally for a certain period of time, and that because she couldn't open her jaw wide enough. She testified that her nose was broken in 2 places, her left nostril was completely blocked, she was unable to breathe adequately through that left side of her nose, and still at time of trial, that was still the case. Additionally, she also testified and she displayed the facial divot that she had, and those pictures, which were taken fairly quickly after the assault that day, she did show, it's clear from the transcript that she showed the divot on her face, which appeared to be clear. Based on all the evidence that was presented, and certainly in the light most favorable to the Commonwealth, and I would suggest for sufficiency purposes, this court does not weigh when evidence is conflicting. So Commonwealth would ask that this court affirm the defendant's conviction.
Do you think the divot in her face would count as a, what is that, a permanent disfigurement?
Yes. This is now something that's different in her face. It's quite noticeable. I would suggest that the case law indicates that scarring is the same, and I would suggest that a divot in anyone's face, much less the fact that this is a woman that's in her 20s, that certainly would suffice.
What do you think? She testifies that she had to have plastic surgery. So what if a victim presents themselves, they actually look fine, but they had plastic surgery? Do you think that they could still qualify for permanent disfigurement? Or
yes, yes, I think the Haywood case that came out actually right as my brief, I filed my brief, indicated that that even where it's fixed, even where you can't tell, like I believe in the Haywood case, actually in the Haywood case, it was 2 titanium rods, and they couldn't see it, but the victim had nerve damage. But I would suggest the case law certainly has indicated that it doesn't matter if it's been repaired.
Okay.
If the court,
I mean, and so right when you need INOA here because because it might be we can't decide on all 3. We have to.
That's correct, and the Commonwealth did file a 16L letter alerting, and I of course recognize that Justice Chin, who wrote that opinion, is on this panel.
Well, sometimes we forget what we wrote, but that was pretty recent, so she probably still remembers.
Well, I certainly can go over that, although I'm pretty confident that Justice Chin, I'm sure, remembers it. But in that case, which was assault and battery, dangerous weapon, serious bodily injury, the serious bodily injury, like assault and battery, assault and battery, serious bodily injury, the element of serious bodily injury need only can be proved through 3 ways: substantial risk of death, impairment of a bodily function, limb or organ, or permanent disfigurement. And in INOA, the court determined that that those three ways are not distinct theories, that they in fact are related ways to prove the same legal concept. And certainly I would, certainly there was no evidence of substantial risk of death, but based on the fact that for a no, the Commonwealth only has to prove via one theory, certainly the Commonwealth met its burden in this case.
Yeah, do you have anything else? I don't see any questions.
No, unless the Commonwealth would rest on its brief.
Okay, well, thank you very much. Thank you for participating by oral argument by Zoom here. I hope you are both doing well and stay safe and stay well, and your clients as well. And we'll take this under advisement.
Thank you.
Thank you, Your Honor.
Massachusetts Appeals Court oral argument session. I'm Greg Massing, and our panel today is Justice Shin, Justice Ditkoff, and myself. As you know, this argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. We'll follow the same rules as in the physical courtroom. Each side has 15 minutes to argue, and we will ask questions. Only one advocate may speak at a time, and in fact, the session clerk will mute the advocate who's not speaking. There's no rebuttal, as is our usual rule. And once we get started, Clerk Sullivan will display a countdown clock so you can see the time counting down. This argument is being recorded, and anything said, of course, will be heard by all those observing and will become part of the record, just as in the physical court. If we have any technical problems with Zoom or with any of your connections, the clerk or one of us will stop argument and announce there's a problem, and we'll try to fix it. We might have to put you in the waiting room to fix it, but hopefully that won't happen. As always, we've read your briefs and are familiar with the case. Although you're free to use all 15 minutes, we won't hold it against you if you don't. And with that, I'm going to call the next case, which is Commonwealth versus Christopher Davis, 19P612. Counsel for the defendant.
Yes, Your Honor. Good morning, and may it please the court. Prior to addressing the substantive issues in this case, I would ask the court to consider a dispositive threshold.
Just one second. Could you pronounce your name for us so we can get that right?
Certainly, Your Honor. My name is Joseph Zlatnik, and I'm appearing on behalf of Mr. Christopher Davis. Thank you.
Thank you.
Judge Massing, isn't this a Commonwealth appeal?
I believe this is a Commonwealth appeal, so I was surprised why I went first.
You shouldn't. My mistake. Megan, can we start the clock again?
All set.
I apologize. Thank you for being on your toes there, Justice Ditkoff. So ADA, well, can you pronounce your name for us, please?
Yes, Tara Ganguly for the Commonwealth, Your Honor.
Okay. Good morning.
Morning.
Sorry about that.
That's okay. Good morning. Your Honors, this is not your typical appeal involving the allowance of a motion to suppress. The defendant in this case is a sophisticated informant with a long criminal history, and he had been ostensibly cooperating with the police for 2 to 3 months at the time of the police interview in question. Mr. Davis had provided an eyewitness account of a homicide that led to a murder indictment, and the police had reason to believe that he was not telling the truth, and they had to try to get to the bottom of what was going on in this case. There are 3 issues that I'd like to point out to the court this morning. Number 1, the police advised the defendant of his Miranda rights 3 times, and the defendant waived his Miranda rights 3 times, each and every time. Number 2, the motion judge committed an error of law by failing to engage in the totality of the circumstances test regarding both the Miranda waiver and the voluntariness of the defendant's statements. The judge's focus on the defendant essentially being stuck between a rock and a hard place was not relevant to the necessary legal analysis. The court cited no evidence, and there was no evidence of police coercion in this case. Number 3, I'd like to distinguish certain cases and arguments that the defendant makes in his brief.
And what's
Now,
tough about this case, counselor, is we've got 2 contradictory findings. The judge finds that David initiates the discussion and voluntarily agrees to proceed without an attorney. and then finds the counsel does not prove beyond a reasonable doubt the defendant voluntarily waived his right to counsel. So what do we do when we have in the same opinion a finding of voluntariness and a finding of non-voluntariness?
I think the judge in this case found voluntariness. I understand what was written, but I think the judge in this case found voluntariness and still was not happy with the way that the judge thought that the defendant was essentially pushed into a corner, and that's why he agreed to speak. But the judge explicitly found in his written opinion that the four police officers who testified in this case, the judge credited all of their testimony, and those 4 police officers, all of their testimony indicated that the defendants, both the Miranda waiver and the voluntariness of the statements were all voluntary. So
the key moment here, it seemed to be the 45 minutes that are not recorded, where, I mean, although the judge does make this finding that, I mean, although the defendant he acknowledged Lieutenant Foley's explanation that, yes, I did say I wanted to speak to you without my counsel, the totality of the circumstances, he goes there voluntarily, but then when he tries to leave, they say, oh no, now you can't leave. And then when he asks for counsel, they stop the meeting, and then they put him under arrest after he asked for counsel. And it's only then that he clearly and unequivocally waives his right to counsel. But at that point, hasn't under the totality, isn't the atmosphere a pretty coercive one?
the atmosphere has definitely changed. The atmosphere changes. He's given his Miranda rights once, he waives them. A little time goes by. Davis says to Detective Lieutenant Culver, I'm done talking with this dude. He tries to get up and leaves, and they bring him back. At that point, the Commonwealth admits the defendant is absolutely in custody, and the tenor of the meeting changes. He's then advised of his Miranda rights again. He says he understands each right, but then at the end of that second Miranda interaction, he says, I would prefer for my lawyer to be here. The police then scrupulously honor that invocation of counsel. They end the interview, they turn off the video recording. During that 45-minute break, it's then the defendant, the police don't do anything. It's then the defendant who, in his own head, decides to change his mind again and go back.
There's an intervening moment there. Detective Foley testifies that he actually goes and talks to DA Capeless about, can I put this guy under arrest? And the DA gives him the authority. So he comes back and says, okay, you're under arrest now for perjury, right? What's going on right now. I mean, that's a little, and that's different from the typical Miranda situation where you're under arrest. Now I read you your rights. Do you want to, here the arrest seems to be in response for him exercising his right not to talk.
It is different, but I don't believe legally that the intervening arrest, he goes in, he's not under arrest. At some point he is under arrest. Arrest is not the relevant question when it comes to Miranda. Custody is the relevant question when it comes to Miranda. And even after he's under arrest, he's given his Miranda rights again, and he waives them. So, and he agrees with Lieutenant Foley. Lieutenant Foley didn't put on the video that he went down and spoke to the district attorney. He did testify to that, but he puts on the video, and the defendant says a number of times, 100%, this is what happened, when he's agreeing with Foley.
And so and when you talk about totality of the circumstances, what you're talking about is the defendant's experience with law enforcement And the fact that he does specifically at this point agree that he has asked to speak to waive his right to counsel. That you're
Yes.
saying that he knows what he's doing. It's not coerced.
It's not coercive. He knows what he's doing. The motion judge doesn't talk about the Mandeal factors, the promises and inducements, emotional stability, education, intelligence. This defendant has a lot of experience in the criminal justice system. There was some testimony at the suppression hearing regarding whether anyone believed that he was mentally unstable or under the influence of drugs or alcohol, and there wasn't any evidence of that. So those are the factors that the Commonwealth submits that the motion judge did not correctly take into account or take into account at all.
So at the point when the defendant says he's done talking and tries to walk out of the room, he says something that I couldn't make out on the video, but apparently something about an attorney. Is it your position that he did not invoke his right to counsel at that point?
I believe he said, I'm done talking with this dude, and he was walking out, and I believe he said, lawyer should be here, or something like that. I think it's a little bit unclear, and I don't think that was specifically focused on in the suppression hearing, that specific moment. But even if he did ask for a lawyer right then, they did bring him back. No substantive questioning took place between that statement when he walked out. He's brought back. There was a little essentially verbal scuffling going on, but there wasn't.
They tried to persuade him to keep talking by saying this is just a test for your, when you get on the stand, right? So if in fact he had invoked counsel at that point, that shouldn't have happened, right? I think there are maybe, at least a few minutes where Foley is trying to get him to continue the interview.
Well, Foley is only on camera Foley's not in the interview, all of the interview himself. I'm not sure if you're referring to one of the other officers.
I'm referring to when the defendant says he's done talking, he's mentioned something about an attorney. Souls then tells him you're not free to leave. So they bring him back into the room, and then Foley and I believe it was Heen come in, and for a few minutes they talk to him to try to get him to continue the interview, saying that this is a test for when you're on the stand. So my question is, if he in fact invoked at that point when he tried to leave the room, was that proper?
I don't think it was I admit, I don't think it was the best course of action, but I don't think that it required suppression at that point if he did invoke when he was walking out of the room and it was a little bit muffled. But if he did, there was no further substantive questioning between that moment and when he again waives his Miranda rights. So I don't believe that.
But it still adds to the coerciveness of the entire situation, does it not?
It does. Yes. But that is one factor in the totality of the circumstances, and no one factor is determinative or not.
Can you address, the defendant says that even if there's a waiver here, that the statements are still not voluntary, and that he thinks we need a remand for that. And you argue we don't need a remand, but you also argue that there's no findings on the Mandeal factors here. I mean, do we need a remand? So what is your position both in terms of a remand on the first issue and then a remand on the second issue?
I don't believe a remand is necessary at all, because the motion judge found each of the four officers, he credited their testimony. So you don't have to look back. We don't have to give the motion judge an opportunity again to make any factual findings. And this court is in the same position as the motion court to evaluate everything on the videotape. So this court can make the totality of the circumstances findings on both the Miranda waiver and the voluntariness of the statement. So I don't believe that remand is required at all.
Well, so if we reach the merits after the 11 o'clock invocation, aren't there several places where the police are basically giving you a now or never, you've got to talk now, you're at a crossroads, they kept saying that. I mean, isn't that sort of classic indicia of non-voluntary statements?
I don't believe so. I think the police were being somewhat tough on the defendant, but this was a sophisticated defendant. He had a relationship, at least with Officer Sewells, and you know, he eventually everyone does get to the point where Mr. Davis makes statements that are the truth. And I think it may have took some time for the officers to get him there. But again, in the totality of the circumstances, I don't believe that there was any severe level of coercion with this defendant. Moving on briefly, just to a couple of things in the defendant's brief. I just want to distinguish Maryland versus Schatzer. In this case, the defendant was the one who reinitiated contact in that 45-minute break with the police. Maryland versus Schatzer and Edwards versus Arizona, the presumption of involuntariness doesn't apply where it's the defendant who reinitiates that contact. And second of all, just briefly about the jurisdictional issue and Rule 15A2 and 278-28E. The defendant relies on Commonwealth versus Ruiz to basically argue that the Commonwealth should not be able to have this appeal. The single justice is the gatekeeper. In this case, the single justice allowed this full bench to hear this appeal. There was no motion to strike or motion to dismiss the case. And Ruiz was about 15A1. This is a 15A2 case. If there are no further questions, I'll rest my brief.
Oh, actually, I'm sorry. I do have one question. There's mention in the hearing about an unofficial transcript of the interview, and I understand there are problems with that transcript, but you don't happen to have access to that, do you?
I do, actually. I reviewed it. I know there was discussion during the suppression hearing about defense counsel not being happy with the content of that transcript, but if the court would like it, I'm sure we could come to, I think it accurately portrays probably 95% of the words. Yeah, I'm happy to submit it.
We wouldn't take it as necessarily accurate, but it's always easy to start with something and then make changes to it as you listen to the tape. I would like to get that.
Yes, Your Honor.
Okay. Well, so we'll hear from counsel for the defendant now. Thank you, Ms. Ganguli, for coming all the way from Berkshire County to get here.
Good morning, Your Honors, and once again, Joseph Zlatnik on behalf of Mr. Davis. May it please the court. I'd like to begin by actually discussing that Ruiz issue, because I think that that issue, the procedural issue in this case, cuts off the rest of this appeal at the knees. Commonwealth versus Ruiz, I'll quote it. It says, circumstances in which the trial judge's decision forecloses the Commonwealth's opportunity to go forward with the prosecution altogether. That's what's required to get on appeal. And there's no cutout for 15B.
I think the AD is right that there's a difference between 15A1 and 2. That the Ruiz didn't have to do with the motion to suppress.
Your Honor, if I may cite a footnote in Ruiz that specifically talks about motions to suppress. Footnote 19 of Ruiz, and I'll quote the footnote right here. Decisions excluding the Commonwealth's evidence are only appealable if, as a practical matter, that ruling would terminate the prosecution. That's language right out of Ruiz. The Ruiz court recognizes motions to suppress as specifically being affected by that decision. Again, footnote 19, I would ask that you look at it. And because Ruiz is sort of the law of the land when it comes to the procedural posture in this case, because the ADA in this case actually admitted that they can go forward with their case, the Commonwealth is not entitled to an appeal here. And I would suggest that this court should and must essentially decline jurisdiction over this case. That said, Your Honor,
did you make that argument to oppose the Commonwealth's petition to the single justice?
I certainly did, Your Honor. It's absolutely in my brief to the single justice. The single justice allowed the Commonwealth's appeal without in any way addressing that argument. I believe that it was properly raised, properly preserved, and again, I believe this honorable court should decline the Commonwealth's jurisdiction to even hear this appeal. And I think it's an important issue. I really think that that procedural threshold issue really is the law of the land on this case, and I ask this court to rule on that issue. But that said, Your Honor, I don't want to belabor the point that—
Pardon me, counsel. Do we have jurisdiction to review that decision? We as the appeals court?
Your Honor, and I mean, I certainly mean absolutely no disrespect to the appeals court. However, to me, Ruiz specifically says under these circumstances, these appeals, again, they use the word foreclose the Commonwealth's opportunity. That's strong language. The Commonwealth's opportunity to appeal this case is foreclosed. To me, that says there is no jurisdiction. And Your Honor, this is a 2018 case, relatively recent, good law, never been challenged. The Commonwealth has not raised a single case to suggest that that case is bad law or that it is inapplicable here. I suggest it is applicable.
Well, could you have appealed from the allowance of the interlocutory appeal?
Yeah, Your Honor, if I may, I actually don't know the answer to that question. However, Your Honor, again, on the substance of that issue, I raised it in the single justice briefing. I raised it in the brief here. I believe it's been properly raised and properly preserved. Your Honors, if I may turn to the substantive issues. From my perspective, this is a case that goes to the very core of the 5th and 6th Amendment. It goes to the very core of Article 12 of the Declaration of Rights. This is a case where Mr. Davis was actually represented by counsel while being under investigation. The police knew that Mr. Davis had a lawyer, and Mr. Davis's lawyer had been to prior meetings with the police with Mr. Davis. Mr. Davis asked for his lawyer over and over and over. And to address Justice Shin's question to the Commonwealth earlier today, I just want to express, when Mr. Davis got out of that seat and tried to walk out of the room, what he specifically said is he said, I'm done talking to this dude. I'm not talking without a lawyer. We'll have a lawyer here. That's what he said. At that point, Miranda stands for the proposition that all interrogation must cease.
He said what?
He said, I'm done talking with this dude. We'll have a lawyer here. There is an inaudible there. However, it's clear on the video. He says, we'll have a lawyer here. But more importantly, Your Honors, the trial ADA, both on the actual motion record as well as in his brief, conceded that at that moment, there was a clear and unequivocal invocation of counsel. There was a concession by the Commonwealth on this point, and I'm surprised that the Commonwealth now is saying that it's a question. This was a conceded point.
Could you give me a site for that concession?
Your Honor, I would have to rely on a brief. I mean, I'd have to look into the record appendix to find that. I apologize, I don't have that in front of me. I can't brief that issue.
The moment we're talking about is around like 10:06 or 10:08 on the tape, is that right?
That's right, Your Honor. This is a situation where the conversation became a little bit tense and Mr. Davis gets up out of his seat. He had been previously told that he's free to leave at any time. But as he tries to get up and get out, he says, we'll have a lawyer here. And
the concession is written? Is the concession written?
Your Honor, there was a brief filed by the Commonwealth, and in that brief, in the Commonwealth's brief, they conceded that that is the moment when Mr. Davis asked for an attorney. Now, Justice Shin's point is the most important point in this case, in my opinion. At that moment, when Mr. Davis tries to leave the room and says, I want my lawyer here, or some variation thereof, all interrogation must stop. Miranda is as clear as night and day on this issue. But instead of stopping the interrogation, what the Commonwealth's agents did is they had 2 extra people enter the room. They escalated the interrogation. And those 2 extra people began to talk to Mr. Davis and try to, I would argue, trick him by saying, oh, this is just a practice session for a trial that had not been scheduled yet, a trial that was not coming up while his lawyer's not there.
Well, what do we do with the fact that the judge credited that testimony?
Your Honor, he credited. There's no question that he credited, but 2 points. As my sister, Ms. Ganguly has said, you have the video in front of you on this issue. You have the video. And nor did the judge did say that they tried to talk him into, meaning in the judge's decision, he actually says that they tried to talk him into believing that this was being used as in the furtherance of preparing him for trial. But again, you're preparing a man for trial while his lawyer isn't there, while after the lead police investigator says they suspect that he's lying. These are the circumstances of the case.
Well, and can I ask you, just he's represented with respect to some drug charges, right? He's not represented with respect to this murder case.
So now to be clear, this is not clear from the record, but what was going on is that he was respected not just with regard to those drug charges, but as the judge says in his motion, he was working with the police on numerous investigations. Now, this perjury charge hadn't percolated yet, but in every conversation, or rather in several conversations that he had with the police before, his lawyer was there. And the day before, when he showed up on December 20th, he asked for his lawyer. And he asked for his lawyer when they first started, when they were talking about the polygraph exam. He said, you know, I'm being surprised here. What's going on? Should I have my lawyer? So this question of should he have his lawyer or not came up over and over and over again. And I just want to point out that after the police left the room, after sort of trying to talk him into it, at that point, Mr. Foley says, sit down, talk to these guys. So instead of scrupulously honoring his Miranda rights, he's told, hey, this is just all prep for a trial. Sit down, continue talking to these guys. He's then asked by Lieutenant Culver, clearly he is asked, are you good? And his answer is no. And instead of understanding that, hey, he's not good, it just keeps going. They re-Mirandize him. And again, he says, no, I want my lawyer here. How many times does a person have to say, I want my lawyer here? So yes, it's true that at some point he eventually capitulates. He eventually cracks and says, yeah, I'll talk to you. But he didn't actually come back to the police. He didn't do as Schatzer requires, have 14 days to leave the coercive atmosphere, talk to his friends, think about it, talk to his lawyer. No, he was put in handcuffs. And as the judge wisely notes in his decision, he was punished every time he asked for his lawyer. First, he was told you can leave at any time. But as soon as he asked for his lawyer, he's told, no, you're not allowed to leave anymore, sit back down. Then he continues to say, look, I want my lawyer. And then he's arrested, and he's not arrested for anything new. There was no new information that he had provided to them. He was arrested for a crime that they already suspected him of. The only reason he was arrested in that moment was because he asked for a lawyer. So what stronger message can the police send to a person than to lie to them about the fact that they can leave at any time? Tell them that actually, no, you can't leave as soon as you ask for a lawyer, and then charge you with a felony for asking for a lawyer, I would suggest. These are the circumstances that he finds himself in.
Counselor, what normally happens is someone's being questioned and they invoke their Miranda rights. They want their lawyer, they want to stop talking, either way, and then they get sent into lockup, right? Because they can't be questioned anymore and there's nothing to do but process them. How different is that really from this ordinary situation?
Well, Your Honor, I think it comes down to, and I think it's sort of obvious from the video, in that he never actually leaves. This is one small room. He's in this room with, you know, I believe there's approximately 5 police officers that come in and out of that room. The entire time, he never actually leaves. He's never brought to lockup. So although we don't really know what happens in that 40-minute span of time, not with any type of detail, what one of the justices mentioned before is apropos. The only thing that really happened in those 40 minutes is that Lieutenant Foley goes downstairs and gets permission from DA Capeless to actually formally charge him. And so this wasn't a circumstance where he comes back after thinking about it and re-engages as the Schatzer exception would be. He never left.
Can I ask you a question? Is he held in that same room with the tape off, or did they bring him to a different room?
So, Your Honor, I don't know the answer to that question. I believe that he was just held in that room. That's not on the record. I can tell you that's what I was told, but it's not in the record. That said, the entire video, there are at least 2 moments in the video that you will see that he actually is left alone on video, and in both of those moments, he's left in that room by himself. So even in those moments where he's not in contact with the police, he's left in that very room. He's never actually taken elsewhere. And I would suggest that that is consistent with everything else in the video in this case.
I mean, so that's pretty persuasive, but what do we do with the judge's finding that David initiates the discussion and voluntarily agrees to proceed without an attorney? I mean, that's a finding from the judge.
Yes, Your Honor. And again, I agree with the judge's decision. This is ultimate decision in this case. I don't mean to you know, suggest that he got it wrong. But what I would say is this question of that word reinitiation. What does that mean in the Edwards and Schatzer context? Is this a case where a defendant has been let go, has some time to think about it, talk to a lawyer, talk to some friends, and reinitiate by calling the police or coming back in? Or is this a situation where the defendant, who has over and over and over again been coerced, had his rights essentially ignored, keeps sitting in the same room and finally cracks on himself and says, hey, I'll talk? That is not the spirit of the Edwards Schatzer line of cases. The point of Schatzer is that you're supposed to get those 14 days. And yes, you can reinitiate within those 14 days after those coercive circumstances have cleared. And I cited that in my brief. The point of those 14 days is to give a defendant some time to think and breathe. The defendant here didn't get 14 days. He didn't get 14 seconds out of the eyes of the police in this case. So I would suggest that the circumstances here were clearly coercive. That's on the Miranda waiver issue. On the other issue, I do want to take a couple of minutes or rather a couple of seconds to discuss it. I want the court to understand that when Mr. Davis finally adopted the Commonwealth's version of events in this case, he did so because he was shown a police manual that I put in the supplemental record appendix that told him that he would go to jail for the rest of his life. And the only way that he could avoid that is by telling them what they wanted to hear. That's essentially what was going through his mind. And that is what Trooper Heen explicitly told him and showed him in that book. I cannot imagine a circumstance where a person is more coerced. And I suggest that on that issue, the judge should have decided. However, because he did not decide, and because this is a totality of the circumstances issue, where the judge should decide on that question, including what happened the day before, including what happened in those 40 minutes that aren't on the video, I would suggest that it should be remanded. But again, going back to the beginning, I suggest this court should deny the appeal on the fact that the Commonwealth does not have a right to it. And thank you very much.
Counselor, the Commonwealth's briefing below that you mentioned having this concession doesn't seem to be in the appendices. Normally we just get it, but if you've got it, that will save us a lot of steps in the current circumstance.
Certainly, Your Honor, I'll try to find it and I will file it with the court as soon as I can. I would reference to the judge's decision. I believe the actual judge's decision says that the Commonwealth conceded at that point. So there is reference in the decision, but I'll file the brief, and also I will find it the verbal statement in the record minutes. Thank you, Your Honors.
Okay, thank you also, Mr. Zlatter, for coming all the way from the Berkshires to join us today. Very interesting case, well briefed and argued on both sides. We'll take it under advisement. Thank you both.
Thank you.
Thank you.
Greg Massing, and our panel today is Justice Shin, Justice Ditkoff, and myself. As you know, the argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We will follow the same rules as in the physical courtroom. Each side has 15 minutes to argue and we'll ask questions, although you are free to sit if you're more comfortable. Only one advocate will speak at a time and the session clerk will mute the other advocates until it is your turn. And I understand that Mr. Graceffa and Mr. Bay are splitting your time. Mr. Graceffa, 10 minutes and Mr. Bay, 5 minutes? Okay, then you're the appellee, so you'll go after Mr. Rosenthal. There's no rebuttal, and once we get going, the clerk will display a countdown clock in her spot there. This is being recorded. Anything said during the proceeding will be heard by all of those observing on YouTube and will become part of the record. If there's any technical problem during the session, we may stop the argument and take any steps that we need to fix it. We might have to put you back in the waiting room. That hasn't happened yet this morning, so hopefully it won't this time. As usual, we have read your briefs and we're familiar with the case. Although you're free to use your entire 15 minutes, we won't hold it against you if you don't. So this case is 19P1442 O'Neill versus Berquist, and the appellant is Mr. Rosenthal.
May I proceed, Your Honor?
Yes.
Good morning, Your Honors, opposing counsel, and may it please the court. Stephen Rosenthal, I represent the plaintiff appellant, Stacia O'Neill. The motion judge in Superior Court granted summary judgment solely because the appellant did not comply with Chapter 251, the Uniform Arbitration Act for Commercial Disputes. That was a mistake. The act does not apply to this private dispute between two individuals. For that reason, we seek reversal of the lower court judgment.
So you're raising that argument for the first time on appeal, are you not?
Yes, Your Honor, because any sort of argument that can be made regarding the right to arbitrate and the terms of arbitration go to the issue of subject matter jurisdiction, which is a matter that can be discussed at any point in the proceedings, even if the parties didn't raise it below. Certainly, the argument was made. Well, strike that. That's my answer to your question.
Why can the arbitrator's jurisdiction be raised for the first time on appeal? I understand why the Superior Court judge's jurisdiction can be waived for the first time on appeal, but why the arbitrator's?
Well, once again, Your Honor, if the act does not apply to this type of proceeding, then the issue becomes whether the parties agree to any particular form of arbitration, and that is a jurisdictional issue that can be raised at any time.
I'm not understanding. How is the timeliness issue an issue of subject matter jurisdiction?
It's not a time. Well, what the Superior Court judge did was he said that the action wasn't brought in a timely manner under the terms of Chapter 251. And my argument is that we couldn't have, raised that point now because the judge applied the wrong standard. Chapter 251 simply does not apply to this dispute between two private individuals.
But how is that an issue of subject matter jurisdiction? So let's just say, for instance, the judge adopts the wrong statute of limitations from some other statute, and that's never brought to the judge's attention. How can that be raised for the first time on appeal?
Well, if you agree that the act does not apply to this purely private dispute, then the issue becomes whether the arbitrator had subject matter jurisdiction to decide the dispute. And that issue is non-waivable.
That's a separate question. The judge found that the limitations period of the act barred this action because it was not filed within 30 days.
Under the Uniform Arbitration Act.
That does not go to the subject matter jurisdiction of the court.
I'm sorry if I'm not making myself clear, but my point is that the issue becomes a matter of subject matter jurisdiction because this court or any court, not the arbitrator, gets to decide whether there is in fact, authority for her to arbitrate the dispute. May I proceed?
Yes.
Yes, and tell me where in the statute, other than the title, does it say that has to be commercial?
Well, I would just refer to the cases that I cited in my reply brief at page 14. The Massachusetts courts have long held that the purpose of that statute is to resolve commercial disputes. Now, this court determines the legislature's intent by construing those words according to their ordinary and approved usage. I'll refer you to a case not cited in my brief, Litton Business Systems versus Commissioner of Revenue, 383 Mass 619 at page 622. The appellees claim that the use of the term commercial is superfluous because it does not appear in the body of the statute itself, and that the title doesn't mean anything. However, Massachusetts courts give meaning to each word in the legislation. No word in a statute should be considered superfluous. There's a long name to this case, but I'll shorten it to International Organization versus Woods Hole, 392 Mass 811 at 813, the 1984 case.
Well, if two people want an insurance company to pay out the limits of its policy to them, why isn't that a commercial dispute?
Well, this was not a commercial dispute because Travelers had already acknowledged liability and tendered its full policy limit. Now, Berquist and O'Neill, to the extent that they were attempting to recover under that insurance policy, were third-party beneficiaries to Travelers' auto insurance policy with the tortfeasor. Once Travelers acknowledged liability and put all the money on the table, the third-party beneficiaries had won, and there were no rights left to enforce under the terms of that insurance policy.
I thought Travelers was not going to give out the money until it knew who to give it to.
Well, in this case, certainly they said, we don't know, we don't care. Basically, the settlement agreement that was written basically says Travelers is released from all liability, and it's up to the parties to decide how to distribute its money. So the only remaining issue was how to divide the money, and that's an issue that was not covered under the terms and conditions of the policy. It was something for the two individuals to work out. If I can continue, I'd like to point out that the Baldiga case, which is cited in the appellee's brief at page 33, concedes that the title to a statute is helpful in interpreting the body of the statute, even if it's not conclusive. In fact, Massachusetts courts consistently hold that the purpose of Chapter 251 is to promote the resolution of commercial disputes. I would even point out that the one case cited by my brothers that refers to a dispute between individuals is the Cebulski versus Vianney case. And even in that case, if I could refer to, let's see, it's 75 Mass Appellate Court at the very bottom of page 384, this court said, the purpose of the Uniform Arbitration Act is to further, and I'm quoting, is to further the speedy, efficient, and uncomplicated resolution of ... disputes with very limited judicial intervention or participation. Then it goes on to cite two cases, both of which I believe were SJC cases, that filled in that ellipsis with the word commercial. So I go back to my original argument that this is not a commercial dispute. Therefore, it was incorrect for the motion judge to decide the case on the basis of a statute that simply didn't apply. Even if Chapter 251 governs the arbitration, the appellant is still entitled to relief, or at least entitled to relief under Section 12A4 of that statute. The motion judge erred in finding as a matter of law that the arbitrator did not abuse her discretion in refusing to grant the appellant's motion to postpone the arbitration, and then in refusing to accept evidence material to the controversy. The motion judge simply got the facts wrong. He said, oh, the appellant had additional time to submit information, and he stated that the appellant had until January 12, 2018 to submit evidence to the arbitrator. But the record is clear, and I pointed this out in my reply brief, that the arbitrator stated on December 20, 2017, the one day of the arbitration hearing, that she would accept no evidence after that date, even though she knew from that hearing that the appellant was awaiting a decision on her claim for Social Security disability.
Now, did she know that? Where did anyone tell Judge Del Vecchio when they were asking for the continuance that there was a Social Security Administration decision that would be issued if she waited?
I would refer to transcript page 131.
I'm sorry, can you get that to me again?
The transcript, page 131.
131.
This case is nothing like the Bay State case relied upon so heavily by the appellees. In that case, the arbitration hearing had already gone on for 2 days and was scheduled for another. At that point,
Counselor, sorry to interrupt, but I'm on page 131 of the arbitration decision. It's something about MRIs and flexion X-rays.
Okay, bear with me for 1 second, Your Honor.
Wait a second. Did you mean? I think
You
you
have
meant
131.
It's page 129, but it's on page 131
Right, it's 129 of the transcript, 131 of the material that was submitted to the court.
I'm getting it. Now I see it. Thank you.
Okay, thank you. So I was saying regarding the Bay State case that was relied upon by the appellees, there the arbitration hearing had already gone on for a couple of days and was scheduled for at least a third day. At that point, the appellant started asking for postponements. He asked for 4 postponements over the course of several months, and then when the case was scheduled for the 5th time, the appellant asked for yet another postponement because he had just fired his attorney and he needed more time to hire someone else. In the present case, the parties had not even begun the arbitration hearing, and only 1 postponement of an arbitration hearing could be requested.
But in this case, you have an agreement that the hearing was supposed to occur before December 25th. So why isn't that alone enough to justify the denial of the continuance?
Well, Your Honor, the judge, the arbitrator, cited as her reason for denying the postponement the fact that the other party in the case, Berquist, was facing a home foreclosure proceeding, and the foreclosure was scheduled for February 20, 2018. So that was the main reason for denying it. She was
but it was the Berquist opposed the request for a continuance partly on the ground that the agreement says it had to occur before December 25th. And it seems to me, given that there is an agreement, which by the way, O'Neill conceded was valid before the arbitrator, it's really hard for me to see why it would be an abuse of discretion.
Well, there was a valid reason offered for requesting a postponement. Certainly, it would have been well within the arbitrator's discretion to grant that postponement.
To override the terms of an agreement over one party's objection?
Once again, Your Honor, the basis of the objection was what Berquist claims was her dire financial circumstances and the home foreclosure. And in order to alleviate that problem, the appellant offered to have a portion of the money that was being to be divided paid in order to eliminate the foreclosure and relieve her from her dire financial circumstances, so she would not have suffered harm. The other point is that in any event, if the judge said, well, we're denying the postponement because there's this foreclosure proceeding pending, well, the judge didn't pay attention to that either. she didn't issue her decision until March 22nd, which was more than 3 months after the hearing itself. There was no credible evidence that Berquist would have been harmed by the one postponement that O'Neill's attorney requested. So my point is that, number one, the act doesn't apply. Number two, even if it does apply, the appellant is entitled to relief under 12A4, and that the judge should not.
Although, even if it does apply, if it does apply, then you're back to the 30-day problem, are you?
I'm sorry, I didn't hear you.
You can't. If it does apply, then you can't invoke 12A4 because you didn't file within 30 days. So you pretty much have to, yeah.
But the major part of my argument is that the act simply does not apply, because the act does not apply to private disputes. Any commercial ramifications that existed ended when Travelers put the money on the table, had its signed release in hand, and walked away. I see that my time has expired. Thank you very much for your time.
Thank you. Thank you for participating in this unusual way. We'll next hear from Mr. Grissef, I believe, for 10 minutes.
Thank you, Judge. Good morning, all. May it please the court, John Grissef here for Travelers. I will be discussing the case for about 10 minutes, and then Mr. Bay, who represents Ms. Berquist personally, will be finishing up the argument. I was present on the day of the mediation representing Travelers. Ms. O'Neill was there, Mr. Bay was there, all parties were present in Mr. Moan's office down in Brockton. It was a long day, and I was instructed during that proceeding to tender the limits on the policy. It's an odd number, it's about $979,000. Why is that? About $21,000 was paid for a property damage piece of it. Defense counsel, in-house counsel from Travelers, Mr. Otter was present. And at some point I spoke to Mr. Moan, and I put the $979,000 on the table. The day went on, and it became apparent that Ms. O'Neill, represented by counsel, who I believe was from Mr. Schwartz's office at that time, could not agree on an allocation of the money. Toward the end of the day, all parties agreed, and my memory is that Mr. Moan drafted the document that you have in the record appendix, October 5th, 2017, simply putting the matter before retired Judge Del Vecchio for allocation. And at that point,
can I just interrupt you a sec? The parties know who Judge Del Vecchio is because we're in a CMCI arbitration, and she's a CMCI arbitrator.
Correct.
So it's kind of unusual drawing, just having the name out of the hat there, but under the circumstances, because you're in the CMCI offices.
Correct, Judge. I believe Mr. Moan suggested Judge Del Vecchio. Everyone knows her and respects her, retired Superior Court judge, very fair and impartial. And Mr. Schwartz agreed on behalf of Ms. O'Neill, and Ms. O'Neill agreed and executed the document. We then we stepped out, meaning Travelers. The money was there, placed in escrow and so forth, and it's laid out in the brief. Ms. O'Neill requested the continuance. The arbitrator, in her very broad discretions, this court knows under the statute and under the CMCI rules, looked at it. I believe Mr. Bay opposed it because of financial issues concerning Ms. Berquist. And at that point, the arbitration on the allocation went forward. It was a thorough hearing. I think contrary to Mr. Rosenthal's representations, a thorough job was done on behalf of his client at that time. And Judge Del Vecchio took it under advisement. Time went by, we went into 2018, and in March, Judge Del Vecchio issued her decision, and nothing was done. at that point. At some point, Ms. O'Neill clearly received the decision. She was in between counsel. Mr. Noah had either left and so forth. It was a little confusing at that time, but on, I believe the date, Your Honor, is April 17th, she clearly received the decision. And then Mr. Noah filed much later than the 30 days, the petition in Superior Court. And at that point, it was over because the statute, in our view, which I'll talk about in a minute, applies to this situation, and they did not comply with the 30-day rule, which this court knows has been in General Laws Chapter 251, I think, unamended since it was enacted based on the Federal Arbitration Act. Assuming arguendo that the statute applies, they're done. A motion for reconsideration, a motion for enlargement, any type of motion under the case law does not toll the running of the 30 days. It is a mandate that something happened and they did not do it as a matter of just chronological dates. In terms of the statute not applying, we looked at the argument very carefully, and the only thing that is in the statute that talks about commercial per se is the word commercial in the title. I've looked at the cases under our jurisprudence in the Commonwealth. I've also looked at the Federal Act upon which the statute is based. If you look right back at the definition, General Laws Chapter 251, Section 1, the clean, clear, and unambiguous meaning of Section 1 is a written agreement to submit any existing controversy to arbitration. Excuse me. And there is an exception in there for collective bargaining agreement. This court, as we all know, reads the statute as the legislature has written it, and there's nothing in the statute that limits it to commercial disputes. The title, in certain circumstances, and we cited the cases, can be looked at by the court for advice is not the right word, guidance on how to interpret the statute, but it certainly is not controlling.
You know what the title was when it was passed? The act that
I'm going to guess here a little bit, Your Honor, which I hate to do, but I believe it has not changed.
No, I mean, you know, in the official reports, they put a title, but that's not necessarily something the legislature came up with. But when they passed the law in the first place, it's an act to do this, that, or the other thing. Was it an act to provide arbitration for commercial disputes?
I don't know the answer to that, Your Honor. I did not look at the legislative history. That's an excellent question, though. I'm sorry I didn't know it, and it's a good question. But the main point is really 2 points on the waiver argument. And this issue, not only did Ms. O'Neill, she was pro se at some point, represented by counsel at some point, but if you actually look at her pro se complaint, she cites 2, the Arbitration Act. So this whole issue about the inapplicability of the act was never raised below, and in fact, excuse me, was relied upon by Ms. O'Neill. The argument was waived. I read my brother's reply brief very carefully, and I know this court has too, but the waiver argument was not addressed. They have waived it. It was never raised until the matter was in this court. Finally, the whole issue of abuse.
Is there, Mr. Can I stop you for a second? Is it jurisdictional?
Is
the I guess the arbitrability a jurisdictional question?
No, I think it's a statutory construction question. I think the court has, well, I guess it's both, but my view, I've always viewed this case as not one of jurisdiction, but one of statutory construction. And viewing the plain terms of the statute,
Uh-oh, we've lost your feed for a second here. Let's stop the clock for just a second.
yes.
Okay, you're back. I'll give you a few
I have,
more seconds if you need them.
yeah, I'm here. My signal is bounces around a little bit from time to time. But Your Honor, I would go back to the point. I've always viewed this as a matter of statutory construction. And under the statute, can you hear me now?
Yeah.
Okay. Under the statute, it was late and it was not in compliance. And in any case, Your Honor, I don't think the agreement was signed. It was signed by Ms. O'Neill knowingly and represented by counsel. And in any case, Judge Delvecchio had broad discretion under her rules and under the statute to make a decision. There's certainly no evidence of fraud, duress, or anything like that. I can't see the timer for some reason, so I don't know if I'm out of time.
You got about another minute.
Okay.
You want to finish up?
I will just sum up by saying this is a situation where the Superior Court carefully looked at this and affirmed the arbitrator's decision. The decision was plain and correct. And for all those reasons, I would ask this court to affirm the judgment below.
Do any of the, before you stop, Justice Ditko, Justice Shin, do you have any questions? No. Okay. So we'll hear from Mr. Bay. Mr. Bay, did you have trouble hearing us, or?
No, I was just chiming in.
Okay. So it's your time now. You've got 5 minutes.
Thank you, Your Honor. Good morning, everyone. So I'm going to be touching on the two issues concerning the actual arbitration, the alleged abuse of discretion. Now, the plaintiff has alleged that Judge Delvecchio abused her discretion by failing to continue the arbitration when it was requested by her counsel in early November of 2017. As far as the portion that are most significant, as far as what was presented to Judge Delvecchio in consideration of her decision to deny the request for continuance, that can be found on page 6 of the record appendix, volume 2. That is my letter to Judge Delvecchio on November 15th of 2017, where I cite the reasonings for our opposition to the continuance. Another document also summarizing it is on page 27 of the record appendix, volume number 2. It's my emergency petition to compel the arbitration, which I presented to Judge Delvecchio on December 5th of 2017. Basically, what these documents show is that we presented with Judge Delvecchio with basically the history of our dealings with requests, dealings with the plaintiff in regards to this case. Just as a brief background, my client, Marissa Berquist, is the only one that filed a complaint against the defendant driver in this case. She underwent 15 months of discovery. She was subjected to a deposition, and we did everything that a plaintiff needs to do in order to compel an insured or convince an insured to attend the mediation. And that's what we did over the course of 15 months without any involvement from O'Neill whatsoever. Once we actually had that date for mediation on June 26th of 2017, about a week prior to, O'Neill pops up out of nowhere and says, I want to participate in this mediation, having done absolutely nothing. And we agreed to do so. We agreed to kick the mediation off for 3 more months to October. And at that time, as Attorney Graceffa just explained, that's when we agreed to the arbitration agreement. And so at that point, when my client thought that she was going to likely have a reservation on June 26th, it was then continued for another 6 months until December 20th is when we agreed to have this arbitration. And in November, O'Neill was asking for even a further continuance. And I think you have to kind of look at those letters that were provided to Judge Delvecchio to see why she refused the continuance. And despite what O'Neill's counsel says, the primary reason was not the foreclosure, the pending foreclosure on Berquist's home. That was I think it was the last statement said in the emergency petition to compel the arbitration. Almost the entirety of our argument for denying the continuance was the history of the case and our history of having to already continue it 6 months because O'Neill popped up out of nowhere. And that is the reason. And I will say, I think also relevant is, again, another waiver argument by, another waiver by O'Neill in regards to the fact that arbitration was agreed to. You can see that on paragraph 7 and paragraph 8 on page 19 of volume number 1 of the record appendix, where she says in her own verified complaint, we agreed to arbitrate it. Therefore, there certainly was no abuse of discretion on the part of Judge Del Vecchio as far as refusing to continue the arbitration. I'll also note that that her attorney at the time, O'Neill's attorney at the time, who was requesting the arbitration, was retained on November 8th, is when she informed us of this. And the arbitration was set for December 20th. That's 42 days where all O'Neill had to do was collect her medical records. That's it. And it's her own medical records. So there wasn't even subpoenas that needed to be served. So there's certainly, I would suggest, no abuse of discretion. The second issue I'm going to talk about is the SSDI records, which plaintiff claims were not reviewed by the arbitrator. It's just factually not correct. The O'Neill submitted her SSDI records to the arbitrator, Judge Del Vecchio, before the decision, after Judge Del Vecchio's decision was issued. The O'Neill's counsel submitted a motion for reconsideration. And with that motion for reconsideration, O'Neill submitted her Social Security disability records. And Judge Del Vecchio reviewed these records, which she notes on page 147 of volume 2 of the record appendix in Judge Del Vecchio's May 16, 2018 decision denying the motion for reconsideration. That's all.
Okay.
Thank you.
Thank you. Justice Shin, Justice Didcoff, any questions?
No.
Okay. Thank you all three for participating in this unusual way, in this unusual time, but okay, no, you turned out my volume. Good morning, welcome to the Massachusetts Appeals Court oral argument for May 11th. I'm Greg Massing, and our panel today is Justice Shin, Justice Didcoff, and myself. As you know, this argument is being held on Zoom, and we're being live streamed on the Appeals Court YouTube channel. We'll follow the same rules as in the physical courtroom, except you don't have to stand. Each side will have 15 minutes. We'll ask questions. There's no rebuttal. We'll have one attorney speak at a time, and the session clerk will mute the other one until it's your turn to speak. There's no rebuttal. And once we get going, we'll have a countdown clock shown. We're recording this proceeding, so everything will be heard by all of those watching on Zoom, and will be also archived, so it'll be as we do with our regular oral arguments, although they're generally only audio archived. If we have any technical problems, we might have to stop the clock and resume the session, but hopefully we won't. We might even have to put you in the waiting room if necessary, but this is the fifth argument of the day, and so far we haven't had any of those problems. So as always, we have read your briefs. We're familiar with the case. You're free to use all 15 minutes, but if you end early, we will not hold it against you. The case is 19P978, Philby versus Carr. And I believe attorney, is it Oline? Is for Mr. Carr is the appellant, right?
Yes, Your Honor.
Okay, the floor is yours.
Thank you. Good morning, members of the panel. May it please the court, Elizabeth Oline on behalf of the appellant Frederick S. Carr Jr. This appeal presents the question of when communications between two parties about the terms of a personal loan stopped being admissible business negotiations and became protected settlement communications. This is a question of law that the court reviews de novo. Clarification of this issue is important because it could apply to any dispute about the terms of an ambiguous agreement and the efforts of the parties to clarify the meaning of a term left open. The night before trial, the judge granted motion in limine number 3, and the next morning confirmed his blanket ruling, excluding for all purposes discussions regarding the parties' attempts to resolve the payment timeframe and interest issues that occurred after the loan was first discussed in 2013.
Seems that the judge
The ruling,
only excluded counsel. It seems that the judge only excluded the emails that were attached to the supplemental memorandum that the judge asked for.
So the judge's ruling the morning of trial, which is in the record at volume 2, page 6 and 7, was that it's discussions regarding the parties' attempts to resolve the payment time frame and interest issues. The specific communications, though, that applies to everything that happened after. The specific communications that were identified in the supplemental memorandum to motion in limine number 3 start with the November 4th, 2015 communication. But then the November 20th through December 1st, 2015 communications were allowed. But then after that, again, the December 3rd, 2015 communications forward were excluded. That ruling is an error of law that does not require the resolution of any conflicting testimony, and it exceeds the bounds of Section 408 of the Massachusetts Guide to Evidence because it erroneously excludes discussions that occurred before the date the jury determined performance was due, so there was not yet a disputed claim, and also before there was any threat of litigation, which is the threshold stated in Section 408 that Massachusetts has adopted.
But how is the judge supposed to rule on a motion in limine based on what a jury will find 2 days later?
I'm sorry, Your Honor, could you repeat the question?
You're saying one of the reasons why it's wrong is because 2 days later the jury found that the performance was due at a date later than that, but certainly it was the position of the plaintiff that it was due even earlier, a year earlier. So how is a judge supposed to rule based on a motion in limine based on something the jury won't do for 2 days?
Well, Your Honor, this is why the judge's decision was so prejudicial. There was a term of the agreement that was not yet determined. It was a term that was left open. And the parties had been in a personal relationship. This loan had been made with the idea that the house would be renovated and then sold and they would buy a new house together. That plan necessarily couldn't happen after they broke up and they realized they needed to fill in a term that they had not yet decided. The exclusion of this evidence would have made a material difference when the jury implied the term because it shows that the parties previously there was a subjective belief on Ms. Philby's behalf that the term was 1 to 2, maybe 3 years. That's an indefinite term that necessarily can't demonstrate agreement. And Mr. Carr testified that he believed.
I don't understand why it can't. I know your position was there was no agreement at the time that the money was turned over. But if I lend some money to Judge Massing and I said, you're going to pay me back in 2 months, 3 months on the outside. Then if I sued him after 2 months, he could say, no, you said 3 months on the outside. 3 months and 1 day, I can sue him. I don't know why that can't be a term, just because I phrase it that way.
Well, so Section 408 applies to exclude evidence about a disputed claim. And in Your Honor's hypothetical, there would not be a disputed claim about the time for performance until after the outside of that limit. And these communications occurred prior to September 30, 2016. So these were communications that occurred at the earliest possible date that anyone has ever suggested the loan was due. And so
it seems to me that the import of your argument is that she couldn't even file suit until September 2016 because no controversy arose until that point. And that couldn't be right. If somebody makes clear that they don't think they have an obligation to repay for over 10 years, seems to me the dispute's pretty concrete at that point. So I guess I'm not seeing why the September date is really all that relevant.
So Ms. Philby certainly could have sued at any point, but the reason that there was not yet a disputed claim is because no one had yet agreed to a maturity date. There was an understanding, there was no dispute that Mr. Carr had an obligation to repay the loan, but where
that's the dispute, and that's why she could file suit, which means there's a disputed claim. It doesn't matter that the jury ultimately found the date they agreed to was September 2016, so long as he's made clear that he doesn't believe he has to repay until I think it was over 10 years later.
Right. So, but she also didn't believe that he had an obligation to repay the loan yet. She also didn't believe, as the excluded evidence shows, that the performance was yet due. Section 408 does not apply to future performance. That's why Massachusetts uses the threat of litigation threshold. The judge did not consider that at all in his ruling.
Counselor, on November 20th, 2015, your client sends the plaintiff an email, and attached to it is a release that he wants signed. I mean, so how could there not be a dispute at that point?
This was part of the parties' business negotiations. Ms. Philby, in the email that was excluded prior to that, so it does make the ruling arbitrary to the extent that her email that came before that would be excluded, but his email that came after would not be excluded. She had proposed a date of 2017, and this is, I submit, the parties' attempts to resolve what was an imperfect contract prior to the start of these conversations. In fact, as you can see, they eventually...
If there's no existing dispute, then why would your client ask for a release of all claims?
I believe that was for a release of all claims in the future. Our client is not an attorney. These were two lay people who were trying to work out the terms of an agreement pro se. Later on, after Mr. Carr suggested a maturity date of 2024, Ms. Philby accepted that, and in fact had a transactional attorney send Mr. Carr a agreement for him to sign, incorporating exactly the terms that he had suggested. She did not need to do that if she truly believed that performance for the loan was already due. By the time her trial attorney sent a demand letter, she could have had her attorney simply demand that payment is due right now, but that's not what she demanded. She demanded that this new agreement be signed, which had a maturity date of 2020. So
she's compromising to show that it's a settlement negotiation. She's compromising. She wants him to compromise, meet in the middle. Isn't that just a classic settlement agreement?
But it's not protected by Section 408 because the parties had never reached an agreement. There has to be an agreement on when performance is due. And this was future performance. In all of the cases that are cited in the briefs, it is the resolution of a presently due legal claim. It's not the resolution of a future claim.
Let me ask you this. If we don't accept that your client was right as a matter of law, that there was no agreement as to when the loan had to be repaid at the time it was made, do you have a claim about the exclusion of settlement offers? You keep arguing this in terms of you just announced that your client was right about the key disputed fact, which is whether at the time the loans were made it was established that they would be repaid within 2 years, within 3 years. So if you're wrong about that, that the jury couldn't find, that a finder of fact couldn't find other than your position, do you still have your argument about the exclusion of the settlement offers?
Yes, because this was necessarily prejudicial to the jury when they made their finding that the they implied a reasonable date of September 30, 2016. There's nothing in any of the spoken testimony or any of the written evidence that was included or excluded that the parties ever agreed to that specific date. All we have is Ms. Philby's subjective belief that they had agreed to a term of 1 to 2, maybe 3 years after they renovated the house and then would sell it, versus Mr. Carr's position that appears in the evidence that was admitted that it was 2027. When the jury, the jury's decision was against the weight of the evidence when they found that they had agreed to that date. But even allowing the jury to imply a date, they needed to have all of the communications that occurred, because accepting the September 2016 date, there was no performance that was due yet. And so the parties were simply talking about filling in the term that was left open. And there was previously, it was a future legal obligation that was due.
Can I ask you, if you'd gotten the stuff into evidence, how would you have used it? What would you have established?
We would have established that the parties had, in fact, because these were not protected settlement communications that couldn't be used to show validity.
No, so what did they show?
They would have showed that the parties eventually did reach agreement. They agreed.
And what agreement did they reach?
They agreed to the maturity date of 2024, and we also would have been able to show that they always anticipated an interest rate. Additionally, we also would have been able to dispute Ms. Philby's statement at trial that she was horrified by a maturity date of 2027. She, in fact, had an attorney send Mr. Carr a promissory note demanding that he accept a 2024 maturity date. That's a significant difference from 2016. It's a significant difference from 2017 that she suggested in the November 4 email. So the exclusion by keeping out the November 4 email, then letting in some November and December emails, but then keeping out the other emails, necessarily let Ms. Philby create a false narrative about what had actually happened. So in conclusion, for these reasons, we ask that the court grant a new trial because the exclusion of business negotiations is an error of law that injuriously affected Mr. Carr's substantial rights, where the absence of this evidence materially affected the jury's decision to imply a date of September 30, 2016. And thus the jury's verdict was against the weight of the evidence, where the jury found September 30, 2016, but there was no evidence that the parties ever agreed to that date. Thank you.
Any other questions?
No.
Okay. Thank you, Ms. O'Lean. And Mr. Carroll.
Thank you very much, Your Honors. Let's be clear in total context here that Mr. Carr has used the court system to delay for as long as possible his payment obligations to Joan Philby and force Joan to litigate for 4 years to protect her rights. At every opportunity from 2015, before we even got involved, through today, Mr. Carr has tried to take advantage of every opening he could think of to distort the facts and hide the truth and delay, his undisputed payment obligation to Joan. This precise issue was the subject of extensive oral argument in front of Judge Henry.
Counselor, like your sister, you're assuming that you're right. If he's right that the actual agreement was to pay it in 2027, then he's not doing anything wrong.
No, except that this is exactly the issue that was discussed with Judge Henry. Judge Henry saw through the arguments that were being made and exercised his role as gatekeeper, as he was supposed to do as a trial judge. And so what had happened was the argument was your first question today, Justice Discoff, was right on it, was that there were specific communications that we had argued should be excluded because they were clearly evidence of a compromise. What Judge Henry, and if you look in the supplemental appendix, what we submitted, there was a January 8th hearing, and then there was also a second hearing on this at the pretrial on January 22nd, or actually it was post-jury selection. And what Judge Henry said there is that he was not just basing his analysis under 408 principles and was there a compromise. He also did it under relevance grounds. And his determination was that the proper issue was what was the time frame for determining what did the parties agree to. And our argument was, and it was supported not just by what Joan Philby testified to, but also by what Mr. Carr had written in his email communications about what was the scope of their agreement back in 2013 when the loans were first issued. And what Judge Henry said was that Ms. Philby's, the evidence in the emails that were part of the motion and in our verified complaint was that what we argued at trial and what she testified to was that her understanding was that the whole point of the agreement was to fix up the house, repair it, sell it for maximum value. That was going to take 1 to 2, at most 3 years. And then they were going to buy a house together after the house was sold and she was going to be repaid. And somewhere along the line, their relationship broke down, the construction stopped. And it came up in September of 2015, and this was around Labor Day weekend, where it came to a head in a telephone call between Joan Philby and Mr. Carr about when was he going to pay this back because the work had stopped in her view. And in that discussion, it was clear that he had no intention of paying her back immediately, no intention of completing the work, and no intention of selling the house. And so technically the earliest state that you can say that there was an actual clear disagreement was in that phone call in September of 2015. But nevertheless, moving forward, there were subsequent communications from Mr. Carr where he said, one, we agreed, and we did discuss this back at the time, and we agreed that this was going to be a loan and not a gift. And we also agreed, in his view, that the agreement was the maturity date, if you will, was going to be 14 or 15 years out, which in his view, and I cross-examined him on this, and he testified to it, that his view back at the time the initial loan was made was that he figured that there was going to be a maturity date sometime in 2028.
Counsel, did he write that in any of the emails? I mean, we're already in the trial testimony.
No. They were in the emails that we had submitted where it was in his, I think it was November 20th email, he said, where he attached his note where he said that the maturity date was 2027. And then she responded.
I get that, Counselor. Here's what I'm struggling with. I'm struggling with the November 4th, 2015 email. That's before he's come back with the 2027. It doesn't say anything about a dispute. In fact, it says the thing that's attached to it, this is to document the terms of the personal loan. So I could really use your view on why that particular email was already part of settlement negotiations.
Right. And what we had argued and what Joan Philby testified to was prior to that November 4th email, they had a series of discussions. And it was clear in that Mr. Carr was taking the position that, one, he had no obligation to pay the loan anytime soon, no obligation to sell the house. And Joan's testimony was that his view is that he was going to extend this for as long as possible. And then as they continued to have their discussions, and this was, by the way, this was at the trial, the record appendix, page 99 through 101, there was some discussion about that at the trial, but we also discussed this during oral argument. And the point was there had been a disagreement. And Mr. Carr's view was that there was, and even you can even take a further step back. There's no dispute that the terms of the agreement, if you will, was that they were going to sell the house and buy a new one together. And at the time they sold the house, which was going to be 1 to 2 to 3 years, she was going to get paid back. And when their relationship broke down, and Mr. Carr writes about this in another subsequent email about what his mindset was back in 2013, he says, look, I agree with your general description in a prior email that there's some truth to what you say, that it was going to be 2 to 3 years and we were going to sell the house and live happily ever after. But now that doesn't seem possible anymore. And then he says, we're not going to do that. I don't have the money to continue the repairs. And my agreement was, or his view of the agreement was that the repairs needed to be completed before he sold it. And then he said that, and I like my house and I don't want to leave. And he says this was the discussion back in 2013. And so he's on record. And this was part of their discussions that had taken place in the lead up to the September 2015 phone call when the work had stopped. And she testified to it. They had gone to a wedding. It became apparent to her that his work had stopped. There had been several conversations over the course of 2015 where Mr. Carr was not interested in moving forward with the project and moving forward with the sale of the house and the purchasing the house together. And they effectively, their relationship came to an end on Labor Day weekend of 2015. And then there were some conversations, and Joan testified that she got so frustrated with the position that he was taking and that he wasn't looking to pay this back, that she said, I put everything in writing going forward. And so that first email, that November 4th, there had already been a disagreement between them. And there had already been a breakdown of what the original agreement was, which was to sell that, fix it, sell it, pay her back, and then buy a house together. And so one fundamental flaw in the argument that Mr. Carr is making here is that he says that there was never any agreement prior to the loan transaction and that it didn't occur until sometime later. And they say it's the agreement in March of 2016, where they say that there was a 2024 maturity date and that there was an interest rate involved. And Judge Henry got it right. And I give him so much credit for doing this because he dug into the record on this. And we had two long hearings on this. And one of the things that Mr. Carr's counsel kept arguing was that, well, the agreement that I want to be able to show was what happened in March of 2016. And he responded, it was both in the January 22nd hearing and again on January 23rd when he explained the rationale for what his ruling was that Mr. Carr had denied in his pleadings and had denied all along that there was even any agreement at all, even in March of 2016. And so what he was trying to do was use the preferential terms that he had been able to extract from Joan from the fall of 2015 into 2016, where she wanted to avoid the trial and just get it over with. And Mr. Carr knew exactly what he was doing. In addition to the release that Justice Dickoff identified, you can see that there were, in February, he wrote an email that, well, Joan, and this is to her counsel, the nature of these things are so complicated that while we might agree on some things, other things are not agreed to, and nothing is agreed to until everything's agreed to. And then they point to this March of 2016 note that he says Joan's prior counsel sent saying, sign this or we're done, and sign this by the end of April. And then Mr. Carr writes back on April 27th, well, surely it must be in your client's best interest to settle this case because of the threat of litigation, the cost of litigation, that's got to be favorable to this. And so she should just sign this. But the problem for Mr. Carr is, one, in his pleadings, he said there was never any agreement. And so now he wanted to come back into court and argue that there was and use that against Joan. And two, that maturity date of 2024, there was nothing that had ever been signed to that effect. And he understood, and he wrote in his February email that if nothing's agreed to unless everything's agreed to, and he never did that. And what
Can I ask you a question?
Sure.
So I understand about 2024, but there's a couple of things in here where it seems like your client is acknowledging that the maturity date is the end of December 2017. The first one where she says it's a typo, and then it isn't in 2017, and then the first thing, the thing that's excluded, where she says I'll give you another year, as if to say that I'm good, that 20. So shouldn't the defendant at least have been entitled to use that to cross-examine her and say you agreed to 2017, the end of 2017?
No, because Joan was emphatic during the trial, and this was in her written communications in the exchange with Mr. Carr in the fall of 2015, where they were discussing what they had agreed to back in 2013. She was adamant about it. And she said, our agreement was always all along 1 to 2, at most 3 years. That was it. And so, and that was before she wrote her first loan installment check, which was on September 30th of 2013. And so, and what the jury ultimately ended up doing was giving Fred the most beneficial date possible from what she said the agreement was. And one of the other things that's clear from the evidence at trial, one of the other positions that Mr. Carr had taken during the trial was that, well, we never had this plan to live and buy another house together. And that was never part of the plan, even though he had written in his email that there was some truth to that. But at trial, we cross-examined him, and there was a series of emails starting at early 2013 and including starting in like January, February 2013, and another one on the very date that she wrote her first check on September 30th of 2013, where Mr. Carr was sending her real estate listings and MLS listings of what if we look at this and maybe this is an opportunity. And so it was pretty clear that the story that he was telling at trial and what he tried to tell before trial wasn't true, is that there was an agreement, there was an effort by both of them to look for another house, and the plan corroborated what Joan had said. And so even
Except
with
the problem was the agreement was, we're going to sell the house and live happily ever after.
Within 1 to 2 years.
Let me just answer my, you can ask, they did not account for the possibility of it not happening. There wasn't a contingency plan.
Well, no, I mean, the agreement was, and Joan testified about this, and even Mr. Carr testified about this, was that the plan was to fix up the house, sell it for maximum value, pay her back. And that was another continuing part of this. And this is another thing that Judge Henry seized on, was that there was no discussion, and Mr. Carr wrote this in his email too, that the only thing they ever discussed was whether it was going to be a loan or a gift, and in terms of the legal nature of that. And they never talked about interest rate, and Joan testified to that, is that there was no interest rate needed because this was going to be a short-term thing and this was going to be done quickly. And what had essentially happened was Mr. Carr, who testified multiple times during a trial that he had much real estate experience and he was savvy as a businessman, he knew exactly what he was doing. And he took advantage of the unstructured nature and lack of a written term describing what they had discussed to try to extract a better deal out of Joan. But the problem he had was that he had written some emails where he made it clear that he knew what they had discussed back then, and what Joan had written in the emails to him, there was truth to it. And what he was trying to use was the fact that their relationship had ended, and their original plan, which was part of the agreement, which was to sell the house and pay her back, that had ended, and he tried to use that as an excuse to extend the time. But there's been no dispute that at every moment, and this is in her emails to him back in 2015, that the agreement always was 1 to 2 to 3 years. And Mr. Carr was free to cross-examine her on that, say we didn't reach an agreement. And he even testified that his understanding of the agreement back in 2013 when they made it was that he was going to have a maturity date of 2028. So though that was the two, they had staked out their positions as to what the agreement was in 2013. Joan Philby said it was 1 to 2, maybe 3 years it was going to be paid back. He said, no, it's not going to be paid back any longer than 2028. And he testified to that, and the jury heard that, and they discredited it. And they found that there was an actual agreement back in 2013 at that time, based on the testimony of both witnesses and their writings after the fact, confirming what had been discussed, that the deadline for selling was 1 to 2, at most 3 years. And the jury, contrary to what Mr. Carr is arguing now, that there was no agreement, the jury found to the opposite. And that's a question of fact, and that's an abuse of discretion standard.
Any other questions? Justice Shin, Justice Bickow? No. Okay, I think that's the time, and there's no further questions. So thank you both for your arguments and your briefs. Again, very well done on both sides.